Welcome, 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 everyone. My name is Ceronne Bayley of Ceronne Bayley's Consulting Services, and we are live once again in 2023. In these LinkedIn Lives, just to remind you that we discuss all things governance, all things concerning corporate governance, regardless of where you are at, regardless of where you're working, whether it's a profit company, a not-for-profit company, a public company, a listed company, a private company, regardless of what sphere that you find yourself in these lives, we discuss issues of national importance, significance concerning corporate governance. Yes, now I am based in Trinidad and Tobago, and I know some of you that would have registered as attendees and that have been tuning into these lives are from various jurisdictions around the world. So just to know that these lives that we do is really concerning governance in Trinidad and Tobago. But regardless, we would still love to hear your comments on your experience in other jurisdictions and how governance operates in other jurisdictions. Now, today, this week in particular, this month in particular, I've planned a procurement series. So this entire month, I want to discuss matters relating to procurement. Yes, and today I am very, very excited about today because I have a fantastic guest lined up for you guys to join me. He's just running a bit delayed, but he will be very here shortly. And today we are going to discuss the Public Procurement and Disposal of Public Property Act 2015. Let's get ready. Yeah, this is a significant piece of legislation in Trinidad and Tobago. It was assented to in 2015. Yes, and in the public conversation, in the national conversation, in the media, there has been much discussion concerning the delays in implementing this particular act. And that is one of the things we're going to discuss today. The significance of this act, why it's so important to have it implemented with haste, the ongoing delays in implementing the act, and what we should be doing as governance professionals to get ready for when that time comes, when full implementation comes, so we could just hit the ground running. Yeah, and while we wait, my guest today is Afra Raymond, yes, as advertised. But while we wait for Afra to join us, I just want to give you a brief context on what this act is about, so you can really grasp just how important it is. It is an act to provide for public procurement and for the retention and disposal of public property in accordance with the principles of good governance, namely accountability, transparency, integrity, and value for money. And for all of us in governance, regardless of what title we hold, be it a company secretary, a board director, or a CEO, or whatnot, we know how important those pillars are. Yeah, it is an act that is geared toward closing the gaps within the procurement processes of state enterprises in particular and state-controlled entities that lead to financial hemorrhage. Yeah, I think I see Afra trying to join me here. Yes, just hold on a little bit. I see Afra trying to join. But regardless, so it is the act is geared to closing the gaps that could lead to financial hemorrhage. What is financial hemorrhage? So when you're always talking about this financial hemorrhage, we have to prevent financial hemorrhage. What is that? It's really just a nice way of saying you're stealing, okay? You're basically stealing, right? We're trying to, what the monies and the funds that are supposed to be in the public purse for public purpose, for national issues, for transportation, for health, for education, is going into and fattening the private pockets, the pockets of private individuals. Yes? Okay, let me just give Afra a little feedback here. If you're trying to join me, Afra, you will need to connect your mic and camera before I can add you to the stream. All right? So just connect your mic and your camera before I can add you to the stream. All right? Yeah, so that in a nutshell is what this particular piece of legislation is geared toward. And just from the purpose of the act alone, just from that alone, you can see just how important it is. Yeah, the act makes it an offense to engage in bid rigging, offer and accept gifts of money or any valuable thing, to engage in any form of inducement or any corrupt, fraudulent, collusive, coercive, obstructive practice when soliciting goods and services using public funds. Yeah, it has established an office of the procurement regulator, which plays a significant role in ensuring that these purposes of the Act are realized. Yeah, so it is specifically geared toward white-collar crime, right? So, and this is a piece of legislation that was assented to since 2015, right? And Afra being one of those persons who would have been championing over the years, and within the last year, 2022, to get this act implemented. Yeah, let me just give a full introduction while he tries to connect to his device. Yeah. Afra Raymond is the managing director of Raymond and Pierre Limited. He qualified as a chartered surveyor in 1993, joined Raymond and Pierre in 1995 as an associate, and became a partner in 1996. He now heads the firm's real estate and special projects department and is also responsible for the management of its head office. Afra is also a member of the Trinidad and Tobago Transparency Institute. He also served on a number of boards in various positions, including executive member of the Federation of Black Housing Organizations in London, director of EPL Properties Limited, which is a wholly owned subsidiary of the Eastern Credit Union. He is past president of the Institute of Surveyors of Trinidad and Tobago, having served from 2009 to 2010, and he is past president of the Joint Consultative Council for the construction industry, having served between December 2010 and November 2015. Let me give Afra a little bit of assistance so that he can connect to his devices. Forgive me, guys. Just give me 1 second. So while he does that, what really triggered me to start this LinkedIn Live on this particular topic is a series of letters to the editor that Afra would have written concerning a letter that the Attorney General wrote to the judiciary requesting their comments on the implementation of this act. And this was done in April, since I think April 12th, 2022. And there was a series of commentaries, a series of correspondence continuing after that, right? And while we wait for Afra to join in, I was even motivated to write a letter to the editor as well and join the conversation because of some of the atrocities that I was seeing in the media being bandied about. Yes, the AG requesting the judiciary, with the Chief Justice, to comment on the implementation of an act. And my question is this a normal thing? Is it normal for an Attorney General to request comment on legislation to the judiciary when the judiciary is expected to hear matters concerning this act? I want to know whether or not all pieces of legislation that is being contemplated by the executive, if that is a norm, if it is that the judiciary is normally asked to comment on the implementation of all pieces of legislation, or whether this particular piece of legislation is somehow special in that regard. So that was one of the things that struck me of the whole, concerning the whole series of correspondence and letters to the editor and conversations and interviews and whatnot concerning the matter of implementing this act. Yeah. And the second is the judiciary's response the judiciary's response to the AG, I think in May 2022, and it was really, really concerning, because one of the points made was that they believe that the state enterprises may not be ready for when this act is implemented. And what does that mean? What does that really mean, that the state enterprise is not ready? Is that somehow an excuse to not do it? Is that somehow a reason for the delay in implementing it? If the act is specifically geared toward preventing white-collar crime, right? Do we wait for white-collar criminals to get ready before we implement a piece of legislation that is specifically geared to preventing such actions? So those were two of the main concerns that I had in this whole barrage of conversation concerning the implementation of this act. This act is specifically geared toward corruption. Yeah, there were many gaps before, and it is trying to close the gaps. Right. So while, there would have been many amendments, or some amendments, I think there were like 3 amendments within the years subsequent to 2015. I really think that it is time that the act is implemented. Yeah. I just will ask for your forgiveness. Afra seems to be having some problems to connect to the stream. And I would really like to hear his thoughts on this matter concerning the implementation of this act. One of the things I was wondering, is there some kind of deliberate attempt to delay the implementation of this act? Right? We know what's going on, right? As governance professionals, not all of us may have worked with state enterprises, but wherever we work, right? Particularly, I'm a company secretary by profession. Right? And the company secretary has such a unique position where we know, basically all the information in the company is housed in the heads of the company secretary, and so you see within the boardroom, you see the discussions going on, what's going on. So even governance professionals, accountants, lawyers, CEOs, company secretaries, you would be aware of what is happening. Right? And one of the concerns I think Afra had was the silence of certain professionals, the silence of certain professional bodies, right? In the whole conversation of implementing this act. Yeah, where the professional bodies, why are they not jumping on the bandwagon to have this act fully implemented without delay, without further delay, without any excuse for delay? Any excuse that the state enterprise is not ready, any excuse that the judiciary is not ready. Where are the professional bodies? And we as governance professionals, right, in our particular role in the boardroom or in our offices or whatnot, we also have a role to play in preventing it. We have a role to play in preventing any sort of corrupt practice that we see happening. And even though you may not see it happening, you also have a responsibility. I'm including myself. We have a responsibility to close the gaps that could possibly lead to it. Because, I remember I was in 2018, I was pregnant. And I went into the Port of Spain General Hospital to have an ultrasound done. And the ultrasound machine wouldn't work. Yeah, the technicians and whatnot, you can tell that they were clearly embarrassed by what was happening. But the ultrasound machine, so help me God, just would not work. And even at that time in 2018, I saw those technicians struggling. My mind immediately went to this piece of legislation. Why is it that our hospitals cannot be equipped with a proper ultrasound machine to check the health of the unborn babies? Yeah, so we need all of the funds that the company that the country is generating needs to go where it is supposed to go, right? And this legislation, kickbacks is a no-no, bribery is a no-no, bid rigging is a no-no. Any form of collusion or current practice is just simply a no-no. And we have to be ready to abide by that. We have to respect the rule of law and forget whatever it is that we are accustomed to, and we also have to be willing to call a spade a spade. We have to be willing to say things as they are, and not pretend like the problem isn't there. I remember I worked for a state enterprise many years ago, and I was responsible for developing the monthly report for the department that would go to the CEO, which would then in turn inform the board. And I prepared the monthly report for the department. And I remember my immediate manager telling me, Ceronne, we could leave that out. Or we can leave that out. We'd want to hide the parts that are not pleasant, that may not present you in a good light. Why is that? Why is that even necessary? Why do you even have to be concerned that your position will be jeopardized because you are presenting, this is the state of my department, this is the state, this is where we are at? Why is it that we have to keep pretending that the mess is not there? The mess is there. And the first place of correcting it, of rectifying it, of having any sort of recovery from it is recognizing that it is there and being willing to say it is there. So there's no need to pretend, or we don't want to say this, we don't want to upset this person or upset that person. It has to be dealt with. And the only way that it can be dealt with is to acknowledge it, is to acknowledge the reality of it. Right? And the Public Procurement and Disposal of Property Act, to me, is a very good start in acknowledging what is there and putting systems in place to rectify it. The judiciary is concerned that there be this floodgate of litigations. All right? So there may be measures within the act to prevent that. But nonetheless, why should we be afraid of that? Why should we not implement the act because you fear a floodgate of litigation? Right? There will be measures in place within the act to deal with that. But you can't simply say the judiciary isn't ready or the state enterprise isn't ready. This is since 2015. And, Afra had raised some very pertinent points in his whole discourse over the past year. So I really wish he would be able to log on so that he can share his point of view. Let me see if I can help him one more time. Forgive me. Yes. So, unfortunately, I'm not too sure if Afra will be able to join us today. But fellow governance professionals, I want to urge you, get acquainted with this act. And in particular, any structural changes that may be required in terms of setting up your procurement unit with the appropriate personnel. Remember, in the olden days, I have a 4-year-old and he watches Peppa Pig. And yesterday he kept saying, in the olden days, remember in the olden days when we had our procurement unit as a small little unit within the finance department? So that's now a no-no. You want to have your procurement department separate and apart. You want it headed by a fully qualified procurement manager. You want it properly staffed. Yeah, so we need to become acquainted with the act so we can be compliant to make sure that we are procuring our goods and services in the way that we should. Right? There are requirements surrounding the standstill period. The standstill period, how does it affect the acceptance of a tender? How does it impact the way we are accustomed accepting tenders or entering into procurement contracts? Right? We should become familiar with the standstill period and what that means for us. It changes the game. It changes the norm. Yeah. Public notice of a contract. Are we issuing our public notices of contracts as required under Section 36? Right? Are we publishing the contracts that are awarded, quarterly reporting of contracts to the Office of the Procurement Regulator. These are things that we have to get used to, and we have to make sure that we are on the ball and that we are doing. Right? We have to be aware of our suppliers and contractors' right to challenge and appeal decisions. Yeah. So all of these things are embodied within the Act. So governance professionals, I urge you, whether you are a CEO, whether you sit on a board, whether you're a company secretary, accountant, attorney, senior manager, whatnot, get acquainted with this Act. Get acquainted with this Act so that we can move forward on a right footing and we can correct some of the wrongs that may have been permeating our procurement processes over the years. Okay, so I'm still going to try to get Afra on the stream because I know he has some really pertinent views to share. Yes, I would like to hear what would he like to see from us? What would you like to see from the governance professionals concerning this Act and its implementation? Right. So because you know, Afra has commented on how certain professional bodies have been silent. So what you all should do as well is go on the website of Thinking Man's weblog. He has a blog and he has very nicely provided a timeline of issues concerning the implementation of this Act and what may seem to be just ongoing delays. Okay, I think he is on now. I'm not seeing him to admit. Here we go. Add to stream.
Sorry about that. I had a situation earlier I had to deal with, and I'm finished dealing with it now. So here I am.
Oh, very nice. Very nice. Well, I have welcomed you. I have introduced you. Yes, so the audience is here and waiting. I'm so glad that you were able to join me. And thank you so much for agreeing to be part of the live.
Thank you.
Thank you so much for agreeing to be part of the live.
So how do you want to start, Ceronne? It's a pleasure. Thank you for inviting me here.
No problem at all. You see, I have been following you. You know, I've been following you on your letters to the editor, your weblog, Thinking Man's weblog on your site, and I've been following your views on this particular piece of legislation, the Public Procurement and Disposal of Public Property Act that was assented to since 2015. And I can sense your passion in the fact that 2015, and I can sense your passion that we stick in. You know, and this Act, you know, given its importance, you know, I've outlined for the audience the importance of this Act and the purpose of it. The purpose of the Act is really to prevent corruption, right? It is targeting white-collar criminals. Yeah. So that alone should spark the significance, to let people know how significant this piece of legislation is, particularly for the state sector, because you know how we are accustomed doing things in the state sector, right? So the whole, and that's just the trend of how we are accustomed doing things is the whole reason why this Act may have been needed in the first place.
Yes, so it's very important.
I wanted you to take us through from the time the AG requested comments from the judiciary on the implementation of this Act. I think that was in April last year, April 2022. Yes. And then the judiciary has some responses. And just go through that and what that really means for us here in Trinidad with public procurement.
Right, well, what has happened is that the Attorney General was appointed in the middle, the current Attorney General, Reginald Amor, was appointed in the middle of March last year, 2022. And one of the early things he did in the first part of April was that he wrote to the Office of Procurement Regulation, which is a new institution that's supposed to operate the procurement law. And he wrote to the attorney on implementing the law. Now, this is a very important phrase to understand, implementing the law. Because the law was written by the private sector civil society. I was part of that group. The law was passed. It is Act number 1 of 2015. It's been on the law books 8 years now. January of 2015, it was passed.
Yes.
It has been amended 3 times by the current administration, which is the People's National Movement. And the regulations for the Act, which are the tools that help the Act to operate, those regulations are all approved by Parliament in February of 2022. So the point about it is that administratively, all of the legal things are in place. In addition, the Office of Procurement Regulation is fully staffed. That started since 2018. It's fully staffed. And they have everything ready to go.
Yes.
AG writes this letter to the Office of Procurement Regulation and to the Chief Justice. And the Chief Justice's response, which comes on the 25th of May, 2022, is a 29-page document that was actually, let us be very clear, although Armand went to the Parliament and he went to his first press conference on the 22nd of June, 2022, and he promised to disclose what the Chief Justice said. He described it as traffic stopping. It's 29 pages long. And it really is traffic stopping. The first thing that's traffic stopping about it is that he didn't want to disclose it. He tried to conceal it. So we have high officials who have a very contrary relationship with the truth. Very contrary. And what is more, after I pressed, because I applied under the Freedom of Information to the Ministry of the AG, and then I followed that up with an application after, under the Freedom of Information, to the judiciary. I was pressing from 2 sides. The judiciary published the 29-page document together with an astonishing press release. And that publication was so stunning. Armand was right, it was traffic stopping. It was so stunning. It actually silenced me for about 2 months. Because it was wrong. As we say in Trinidad, it was wrong like a Crix biscuit. It was so wrong. The first way it was wrong.
I saw it.
Yeah. The first way it was wrong is that the Chief Justice, the judiciary, is not supposed to be commenting on a law that has already been passed.
That is what I'm saying.
That is what you do from the bench. But you're not supposed to be writing to the executive to criticize a law that the legislature just passed. And in fact, there's a process to develop a law, a legislative process, a very painstaking and detailed process we participated in, where in fact, any concerns or difficulties or conflicts could have been thrashed out at that stage. And there's a legitimate space at that stage of the legislative process to thrash out those things and to make sure we get what is called good law. It is not legitimate, and I'm saying it very plainly, it is not legitimate for the judiciary at this. It is not even the 11th hour. This is 2:30 in the morning. At this hour, to come now complaining that, please. So the first thing is the question is out of timing. The second point is that the complaints or the concerns that the judiciary has inside of that 29-page document are misplaced, to use polite language. Not a single one of them could withstand serious examination. Not a single one.
I remember reading something about the judiciary isn't ready and the state enterprises aren't ready.
Yes.
That is one that struck me the most. It's like, do you wait for white-collar criminals to get ready to implement laws? Yeah.
Did we wait for every car to have a seatbelt before we brought the seatbelt law? The seatbelt law was either for the benefit of the population or it was not for the benefit of the population. Okay? Just like motorcycle helmets. Did every motorcyclist have a helmet? No. Either the law is for the benefit of the general population or it's not for the benefit of the general population. If it's for the benefit of the general population, a democratic government that is conducting itself properly will put it in place. And in the case of the OPR, the Office of Procurement Regulation, that the AG wrote to, the OPR actually offered to give a 6-month transitional period. So if any bodies are not ready, that 6-month period is when they could use that to hire staff, do training, put systems in place,
and you will
prepare the organization for the new law to be applied all the way across the board. Okay? And the third point I wanted to make, the first point I made, go on, Ceronne. No, go on.
No, but that is expected. A new law is implemented. Yeah. The OPR is established under this new law. Of course, there's going to be a period where they will have to get themselves ready. So that is expected.
Yeah.
You know, yeah. Continue, Afra.
So the first thing is that the judiciary ought not to be commenting on a law that's already been approved by Parliament, other than from the bench. Secondly, and that was not from the bench. Secondly, the comments that were made and the concerns that were expressed are baseless. I'm saying it again, baseless. And thirdly, and nobody who reads the act and the regulations could sustain any of those comments. And thirdly, the judiciary's 29-page submission, the one that the Attorney General was alarmed that he called it traffic stopping and he's waiting until he sorts out all the problems. There was absolutely no supporting evidence or citations, none whatsoever. Now, here's where the irony is what I call a piercing irony. You couldn't go to court and submit a motion to the court without supporting evidence, precedents, research to support what is the position you're advancing on behalf of your client. You couldn't do that. The court would quite rightfully reject those submissions because they're unsupported. Okay? Yeah. The court will reject them.
The judiciary themselves require those supports.
What we are seeing now is a question of professional standards and recklessness in the conduct of matters of the utmost importance. This is what we're seeing here. And the other thing I want to take the opportunity to say, Ceronne, if I may, is that I have it from 3 or 4 judges have communicated with me, and I have it on good authority, that they have judges in the judiciary who don't know what the objections are.
Who don't even know what the objections are.
They don't know what the objections are. They don't understand what they are. They're asking me, Raymond, what are the objections? Okay? That is what we are dancing with.
Yes, and the whole question of the AG requesting the comments from the judiciary at the point in time when they did, isn't there a view of separation of powers there? Well, why would they do that?
This is where it's interesting. I consulted 2 former attorneys general on this point.
Yes.
And both of them said to me that there's a very limited scope for an AG to consult a CJ on an implementation issue on a new law. And that scope, the legitimate scope in both men, I didn't tell them what I was talking to each of them, but their opinions coincided. Both men said to me that the correct and proper scope of the Chief Justice's concerns on the new law would be operational questions, procedural questions. Perhaps we need more courtrooms. Perhaps we need more magistrates. Perhaps we need more Spanish translators. There are a lot of Venezuelans in the system now. Yeah? Perhaps we need a wider entrance because of disabled people. Perhaps we need an area for the children to play because it's a children's court. Practical, operational, administrative measures to make sure the law is smoothly implemented. But no AG, neither of the 2 AGs I spoke with believed that it was right and proper for Chief Justice to express opinions on the law. When his covering letter apparently says we don't express any legal opinion. Yeah, on the law itself. Most of those 29 pages were spent discussing the law itself. Yeah. And that's wrong as far as I'm concerned.
With a preamble, with a preamble that this is not a legal opinion. It should not have been done in the first place.
Yeah. Only them went to school.
It should not have been done. It should not have been done in the first place.
Yeah, only them went to school. Yeah, that's what I always say, my hashtag.
So, which leads me to my next question, that it seemed to me, even the AG's requests for comments seemed to be some sort of deliberate attempt to delay the implementation of the act. That's just my humble view. Do you think that it is a deliberate attempt to delay this act?
It seems so. It seems so, because what is happening is that act is going to pose some serious challenges. Notwithstanding the 3 sets of amendments that I mentioned earlier. And the effect of those amendments, one of them was an administrative thing where they sort of shifted around the appointment dates of the board, which was a bit of administrative shuffling that was necessary. The second one was where they put in place a procurement review board headed by a retired judge to vet complaints before they go into the High Court, which I think was an improvement. We didn't think about it when we wrote the law. It's an improvement. I give them that. And the third one, I think, was terrible. It actually diluted the act, because the third one, in fact, exempted legal fees, accounting and auditing fees, banking and financing charges relating to government financing, and that sort of thing, and government-to-government arrangements. And those things are huge elements in what disturbs the public order now. And I think they need to be in the law. So those are detrimental things. But notwithstanding all of that, those 3 changes, the law will still have a tremendous impact on how we conduct our business in the country. The first point to understand is the size of the state. In other countries, in the more advanced jurisdictions, the size of the state is relatively small compared to the private sector commercial activity. Here in Trinidad and Tobago, I would say the vast majority of commercial activity is somehow connected to the state or state enterprises.
It's done with the sector. I completely agree.
It's done with public money. Yeah. So that's the first thing. The state actually has a huge influence on things. Therefore, an act
and the volume of money.
An act that can bring about that different sort of conduct, will have a tremendous impact. And one of the important impacts is this. We talk in Trinidad and Tobago, when we have one of our scandals, every 9 days we have a scandal. Well, these days it seems like it's every 2 days. But we talk in Trinidad and Tobago about the 9-day wonder. And the one recurring thing that happens with us is that we keep recurring on the point that nobody gets punished, nobody goes to jail, nobody loses their license to practice. We talk about that, okay? And what's interesting is that the procurement law actually takes that as our point. We took that as our point of departure. So in relation to the public sector, any public sector body that is involved in procurement or the disposal of public property has to have someone up. Those agencies are called procuring agencies. They have to have an appointed person, a biological person, not a post. A biological person has to be their procurement officer.
Individual.
An actual individual with a DP and a blood type and the whole 9 yards. That individual is who is actually responsible for procurement in that procurement agency. If there is a breach of the procurement law, let us just say that there are 10 offenses. In 9 out of the 10 offenses, there's mandatory imprisonment. That's how serious we were. Because this problem in Trinidad and Tobago is so huge, it's so complicated, and it's so nasty. The only way to deal with it is how I'm talking about it here. It has to be.
You have to hit it hard, full force.
You are responsible for procurement in TNTech or WASA or wherever, and you do some kind of bubble, prison. And what that does is this. Because up until now, we've had a situation where state enterprises and indeed statutory bodies have taken orders from the government, ministers, line ministers and things, to do this or not to do that. Give this person a contract, don't give that person a contract, get rid of this person, hire this person, and so on and so on. We all know
the political influence.
Yes. Now, what that means, this new arrangement, what it means is that in fact, the procurement officer, the named procurement officer, is the one who will be going to jail. If you do the crime, you do the time. And that person have to really consider, because no minister coming in jail with you, and jail is not nice. But do you really want to sign stupidness? And the other aspect, this thing has dimensions to it. Let me go a little further. Let me add another piece of it to show you something else. The other aspect is that if something is being investigated, so a report is made that some improper thing took place in a particular state enterprise, And that report was made to the OPR. The OPR reports in 28 days. So this thing that's going on and on with the fraud squad and a commission of inquiry, all of that is over. They actually have procedures to get a swift answer to the question. And because it's one person responsible, this story that keeps going around in the room, the Nancy story mixed up with Brer Rabbit, this one and that one and that one and that one on holiday. No.
Swift action.
If something took place at MTS, MTS has a procurement officer. And that is who has to sit down in the chair. The thing with 20 names and 30 names, all of that whole game is over. Okay?
And so it stops with the OPR. When the OPR does the investigation, it stops there. That's it.
Yes. So that is the way the system hangs together. And what that means is that the notion of professional responsibility that has been thoroughly diluted and in some cases discarded would be restored to centrality. Because really, the people in those positions of responsibility will have to act with responsibility and to make sure when they're doing something.
Have to act with responsibility.
Yes, that it conforms to the law. And have procedures. If it is thinking of doing something, you can write to the OPR and say, this is what we're thinking of doing. Is this approved? Is this okay? You can write them and get them to sign off on it before.
But
the notion of who don't know and who don't remember, that those days are over. The other side, Ceronne, is that in fact, which is what's important. See, the thing has dimensions, and the other dimension of it is the private sector dimension. I have always said that there's as much corruption in the private sector as the public sector. In other words, between private companies. I can tell you as somebody who spent my life in the private sector, between companies doing each other wickedness and things that they should never do, but it happens every day. And of course, we know that the private sector people who very often will pay bribes and do improper things in collusion with public officials. Yes?
Of course.
Now, at the moment in Trinidad and Tobago, I'll describe what can happen at the moment, and I'm going to describe how the new system tackles the issue. So let's suppose you have a contractor, a building contractor, who puts up buildings, simple buildings, nothing elaborate like Napa or anything, simple buildings, who puts up buildings, let's say for TNTech or WASA. Those buildings in the pumping station is the kind of simple thing. So you put up a simple building for WASA with the brickwork and the flat concrete roof and the steel door, and they have a pump inside there. And that person had a contract to build 20 of those for WASA. And somehow it was found out that they did stupidness. And the buildings weren't good. And they wanted repairs very early. And when they investigated, they found somebody in WASA had enriched themselves. And that person busted and gone to live in the States, and they realized the fellow already used to pay bribes. The contractor A. WASA can make a decision to remove A from their list of approved contractors. And that happens in Trinidad and Tobago now because they actually have people in the public service doing their job. That happens.
Okay.
That somebody can. You want to repeat it?
No, I'm glad to hear that.
They are understanding public servants, for sure. For sure. A significant number of them, in my opinion. That's not something I'm just saying because of anything. That's a real thing. So the people in WASA doing their job could say, hey, this person is stupid, and they could take the person off their list, remove them from their approved list of contractors. You know, they have like pre-qualified lists.
Yeah. Yes.
Under the system we have now in Trinidad and Tobago, that same person who just got removed from WASA's list could get work at the Tunapuna Piarco Regional Corporation, TNTech, the Port of Spain City Corporation, UDCOT, HDC, because there's no way for UDCOT to know. What they do, they will ask a question when that person is applying to UDCOT. Understand the point? He could be pre-qualified in all those places already. So there's no notification going from WASA to the other agencies. The system we have now,
that's a problem.
There's no notification. And in addition, if he applies to join a new company, a company he wasn't with before, so THA, when you're doing plenty construction, he might say, let me try to get into THA, just to make an example. So he applied to THA, and THA send the form to him and say, fill out this form to pre-qualify. The form has a series of questions, and one of them would be whether you ever struck off. Now you are relying on the honesty of a man who was a scamp. He's not going to say yes. He's going to say no. He's going to say, no, I was never struck off. The system that
but
we are
are
bringing.
They not? Yes, Scott. Are they not required to
go on.
through the OPR? It's one central location you register through the
hold
OPR,
on.
not
I was describing the current system. Okay. And I'm now going to talk about the new system. The new system is one in which there's a central repository of those people. And there's the power for the OPR to disbar somebody for up to 10 years from receiving state work. And that is called, the word for it in law and in procurement practice is called cross-disbarment. So what cross-disbarment means is that you're not going to get any work from anybody in the state. TNTech, WASA, THA, don't matter. Once public money is involved, you have an extra on it.
Yes, because there's a central repository through the OPR, so they are fully aware. This is you have a big X across your name. You are blacklisted because this is who you have demonstrated yourself to be. Yes. So that's not in place as yet.
No, that's not there yet. No. At the moment, we still have scattered.
Registering with individual agencies.
Of list of different agencies, And the effect of that is that we're not getting the best for our dollars. So I'm just giving a few examples for listeners and viewers about what are some of the impacts the new system would have,
But maybe the agencies themselves, okay, let's say you're registering with the agency, not through the central repository. Shouldn't you have some method of due diligence to check and not just rely, well, if he says so, he say he was never delisted, so I'm just going to believe him. And some sort of due diligence to check that.
You know what's interesting about that? When we were doing the procurement law, we tried to come up with a list of how many procuring agencies are there. And I could remember when we started the exercise, this is going to be back in 2010 or something, so we thought it was about 50. We thought it was about 50, 55. By the time we put it together, it might have been like close to 200. The first time the OPR came out, which is in 18, Mr. Monilal Lalchan. By the time Mr. Monilal came out, Lalchan, and he started to talk and activate the public about the issues and things, it was over 200. It was about 228. And right now, in terms of the last 6 months, the sort of the discussions we've been having and the papers the OPR has been issuing, it's about 330. So even like HGC.
And it's growing.
Yeah, this is the point I was saying. Even like HGC, which is a huge statutory agency with housing, affordable housing, they have now created 3 subordinate companies to HGC. They've kept HGC. They didn't dissolve HGC. They've created 3 fresh companies below. So
that was one of the things I noted in the last budget. Keep expanding. Yes, because it's not just the state, it's the state enterprises as well as the state-controlled entities. The state-controlled entities, which is some of those that we may not be able to quote, like we could quote HEC, we could quote PTSC, we could quote MTS, but there are many, many state-controlled entities, and it just keeps growing and growing and expanding.
Yes.
So like you say, the state sector in Trinidad and Tobago is so large, that PSIP fund alone, it is so large, and you laugh because you know what goes on with the PSIP fund,
Yes.
Before we close, Afra, I just want to get from me, I'm a governance professional, right? I'm a company secretary. I was company secretary of a state enterprise in 2015, and I remember going through a lot of training sessions to get us ready, right? So we were all excited and somewhat a little nervous and fearful, like, so are you ready? Think this could work? But I was excited for it. I was like, it has to work, right? It has to happen. I really, really welcomed it. And I remember there was some fear attached to it. Right? It's like, this is going to change the game a lot. Right? But the point is, there are certain practices that is so embedded in our culture, Afra. It's so embedded that you really have to come hard. You have to have, here's what, you do something wrong, jail. Right? You have to come hard to really get that culture that is so embedded and permeated, to attack it hard. So
Yes.
what would you say to the governance professionals like me? I read in one of your blog that you found certain professional bodies are quiet. What would you want to see from us, from the professionals sitting around the table in these state agencies?
Well, what I want to say is this, is that I do not think all public officials are corrupt. There are a lot of professional, hardworking people in the public service. I come from a family made up of those people. And I also know for a fact, apart from my family story, I also know for a fact that there are several state entities that are ready for the law. And I'll call some names now. Okay? That have done all the necessary work to put themselves ready. Every ministry has a procurement officer. TNTech is ready. WASA is ready. HTC is ready. National Gas is ready. Heritage Petroleum is ready. The Telecommunications Authority is ready. And the point I want to say to the others listening to this broadcast, because I know there'll be colleagues and so on listening to this, is if you are in a situation of responsibility within a state entity, you need to take steps to start putting that company or that statutory agency on a footing when they are ready to deal with this new law. This is a new age of responsibility for our country's future, responsibility for our country's resources, and responsibility for our country's future, which includes the unborn children. So, and the ones who little, who too young to understand this. So we have to do the work now, so it'll be easier for them in the future.
That's right. That's right. Thank you so much for that. And just to close off, everyone that's joining in, you can view Afra again as part of a panel discussion on the 2020 OFF report into the construction sector in Trinidad and Tobago. What have we learned? This is a Zoom meeting that's being held on the 7th of February 2023 and is being hosted by the Caribbean Corporate Governance Institute, who continues to do such fantastic work for governance in Trinidad and Tobago. I really thank God for institutions such as the CCGI. Yes, and as a governance professional myself, I just want to thank you. You are a true son of the soil, Afra, true son of the soil, and I will join you as in the fight as a daughter of the soil as well to make sure we see the changes that we need to see happen in procurement in this country. Yes, beautiful. So thank you so much.
My work is at AfraRaymond.net.
AfraRaymond.net.
Yeah, that's where all my
Thinking Man's weblog. A Thinking Man's weblog. Some good reading there, Afra. Thank you so much.
Okay,
and thank you, guys.
Ceronne.
No problem at all. Thank you.
Thank you. Bye-bye.
Yes, so that brings me to the end of my live. I hope you enjoyed. I'm so glad that Afra was able to join me and join me next week again for another exciting series on matters related to procurement and all things governance. Have a wonderful evening, guys. Thank you.